I'm going to talk about estate planning and the considerations that you should take into account when you are looking at doing your estate planning. And also, we're going to talk a little bit of definitions. So really quickly, my name is Allison Katarey. I am a founding lawyer at Bridge City Law Office. We're a small law firm in Stonebridge in Saskatoon here. I do have an accounting degree first before I got my law degree. I am a TEP, which means I'm a trust and estate practitioner, which is sort of a specialized designation. And I'm also a wife and a mom. And the reason that I bring up those last two is that when we're talking about estate planning and we're looking at the considerations that I'm going to go through, you have to start remembering your why. Why are we doing estate planning? What is the purpose of all of this? We could just chuck the money in the river and lay down in the grave and die. You want to consider, why are we doing the estate planning? Why are we trying to make it easier for people after we're gone? And so keep that in the back of your mind, what your why is when I go through these considerations. So definitions are important, and I'm going to go through these because there is some miscommunication and misunderstanding in the industry sometimes about what these terms mean and what they don't mean. So the executor is your trusted individual or corporation that you have appointed to manage your assets and carry out the wishes outlined in your will. Your beneficiary is the person that's going to end up getting those assets at the end of the day in the manner in which you've outlined in your will. They may or may not be the same person, and they have different roles. Your estate is what you own and what you owe. And I have another slide coming up next that talks about what things are not your estate and what are your estate. And your will only covers your estate. And then we have the last one is a power of attorney, who is not your executor. It is a different term. And that is a trusted individual or corporation that's appointed to potentially manage your assets or manage your personal care while you are alive. And that is the key distinction that people need to understand, that a power of attorney has authority when you are here, an executor has an authority while you are gone. Again, may or may not be the same person, depending on what you've arranged in your estate planning documents. So what is your estate? And I make this distinction between estate and non-estate assets, but things can also shift. And so this is not like you look at this once and throw it away in a drawer. You never look at this consideration again. You have to always be mindful of these two boxes. So your estate assets are your land, your house, your cabin, things you real property that you own in just your name. No other name is listed on that title. It includes your bank accounts, again, in your sole name, your sole investments, your vehicles, your shares of a corporation, debts that may be owed to you. So if you have acted as a mortgage company for someone else, you've lent them money to buy land or something like that, and you have an actual registered interest on title, those are debts that are owed to you and they'll form part of your estate. And a newer one that we start to talk about now is digital assets. So those can be things like Bitcoin. Those can be things like social media accounts that maybe have monetization to them. Those can be things like air miles, Avion points, things like that that have a value but aren't like a physical, tangible thing that we can see. So you do need to keep those in mind when you're talking about your will and your estate planning. Non-estate assets are jointly owned property. So most of you have a title here, I'm guessing, own some type of land. Is that in joint name? Is it in tenants in common name, which is an alternative way of owning things together with someone else? Or do you own it in your sole name? If it is jointly owned property in Saskatchewan, land titles trumps will. So if you own property joint with a parent, a sibling, a spouse, upon your death, that land goes to that person. Doesn't matter what you put in your will. Joint bank accounts may go to the joint owner of that bank account, depending on if rights of survivorships have been set up properly with the bank. There's a little asterisk on that, because if you own joint bank accounts with a parent, there may be some presumption that it's intended to be actually going into their estate and you were just sort of holding it to help them, kind of thing. Registered assets that have beneficiaries on them. So again, just kind of like land in Saskatchewan, beneficiaries trump will. If you have it designated, if you have an RRSP that you have designated that asset goes to a specific individual. You've listed a beneficiary. That just goes there. Doesn't matter what you put in the will. Beneficiaries trump. Same thing with life insurance. So the reason why you need to keep this in mind is because estate assets are what your will governs. Non-estates don't. However, assets can sometimes shift into the other box. So if you have a jointly owned title and then one of you passes, now you have an estate asset that was non-estate asset originally. If you have a registered asset with a beneficiary, but your beneficiary passes before you and you are unable to maybe name a new beneficiary due to capacity issues, it's now an estate asset. So they can flip-flop between the two depending on your circumstances. And you should be aware of that when you're creating your estate plan of both scenarios. What if I'm here and what if they're estate assets, what if they're not? I'm going to quickly go through some of the estate planning considerations that everyone should consider. But the third one is obviously more geared towards farming individuals. But these are applicable no matter whether or not you have a farm or not. Avoiding probate. How many of you were taught as a youngster by your grandparents or parents, avoid probate, it's horrible, don't do it, you never want to have probate? It's a common thing in our province. People are pretty scared about it. We are actually the second lowest in Canada in terms of probate expenses. We can't match Alberta. They've done a flat rate. That's just their choice. But we are the second lowest after Alberta. It's $7 per 1,000 of asset value. And when I'm talking about asset value, I mean your estate asset values. The non-estate assets are not subject to probate fees. They are required to be listed, but they are not subject to the fee. What is probate? So probate is just the legal process where an application is made to the court to prove that that will that they are putting forward is your valid will, was properly executed. It lists your executor and it lists your beneficiary, and we know who these people are, essentially. So it's the court order that officially and legally appoints your executor. When do you need it? So probate is always required in Saskatchewan if you own title in a sole name. Land titles will not accept any other authorization other than an officially appointed executor to sign on behalf of your land. However, a bank can also require it. They have their own thresholds. Every bank is unique in their own threshold, but they're all around the $50,000 to $100,000 range, in which they want certainty. They want to cover their own skin to know that they are handing over your assets to the properly appointed individual that you have selected for that role. It can also be triggered if you have foreign assets. So if you have assets out of the country or even out of the province, there may be a requirement for probate that will be created. Death creates an unplanned disposition of your assets. So upon your death, you are deemed to have disposed of everything that you own. The shares in your farming corporation, your land, your machinery, anything that you have in your sole name that's your estate, you're deemed to have disposed of it upon your death. That means all those capital gains can also be triggered upon death. You do have the ability to use your lifetime capital gains exemption, but if you are in a situation where your holding company, your farming corporation has too much cash in it at the time of your death, it may not be qualified farming property. Like she mentioned, the lifetime capital gains exemption may not be applicable upon your death, which is why it's best practice to have sort of an ongoing conversation with your financial advisors and your tax accountants about what do we look like? What if something were to happen? Is this going to create a massive tax scenario? What can be done to potentially forward plan to minimize the taxes that could result? And I mean, no one knows when they're going to pass, but once you reach a certain age, you can anticipate that it may happen in the next 10 to 15 to 20 years. Is there something that we can start tax planning now to try and mitigate the taxes? How to treat everyone fair, but potentially keep the farm intact. So the biggest point here is that fair doesn't always mean equal. And when there are multiple children and beneficiaries, even if all of them are farmers, you must still closely look at what is the best way to divide those assets, because relationships can sour and grievances can rise. And the only way to sometimes address some of those things is to have the difficult conversation and to have a family planning meeting. And the main advice around this is sort of having that family planning meeting early. It's important to know that you're not going to incur a whole bunch of legal expenses or tax costs and accounting expenses for a plan that nobody wants. So if it's a plan that is actually not going to work for the next generation, it's a plan that nobody even wants, why are you going down that road with your advisors? So having that conversation with them is important to know. It also might be a time to look at, should there be a reorganization of assets, adding people to title, removing them from title, changing how ownership is, so that things will pass in the way that you intended them to. Leaving a legacy. So this is a charitable donation kind of situation where you can leave a bequest in your will for a charitable organization. This can be used as a tax strategy as well to offset some of the tax implications that may arise upon your death. There are many different organizations that deal with this type of thing. My only advice really in this area is to be specific in what the intention is. And if you are intending to leave a large bequest to a charitable organization or leave an ongoing legacy, to reach out to that charitable organization and set something up with their plan givers so that it goes where you want it to go and it goes in the manner in which you wanted it to go. Caring for special needs children. So this is another main consideration, particularly if you have individual beneficiaries that may be disabled, whether it's physically or mentally, and they're receiving government benefits, or if you have someone who may inherit but maybe isn't the best person to manage that amount of inheritance, whether it's a financial just budgeting issue or whether it's an addictions issue or something like that. So this is an area in which trust can be created in order to set out who is actually controlling that money, even though it's for the benefit of a different individual, allowing them to preserve their entitlement to the government benefits, creating life interests where they can essentially use the assets during their lifetime, but they don't really actually control and own it. Those are things to consider if you have an individual that you intend to benefit that maybe has some special needs. So the last main point I want to make is about powers of attorneys. So like I mentioned earlier, they are distinct from your will, from your executor. Those are things that are in place now. No one has the right to sign for you just automatically because you're married to them or because they're your child or anything like that. So if you want to allow someone to sign for you in the event that you have lost the capacity to do so yourself, you have to do a power of attorney. If you do not have one and the need arises, a court application is required that can cost in the range of $5,000 to $10,000. It is a significant expense and a significant burden that you are placing on the next generation to help you deal with the situation if you've lost capacity. And your executor has no authority until you pass away. Your power of attorney can help with banking, with selling and transferring of assets, with investing, paying and managing debts. In the event that you've completely lost capacity, they can also decide where you live, which care home you may be placed into, access your medical information, and assist with some medical decisions. They cannot change your beneficiary designations. So if you lost the capacity, those are set in stone at the point you lose capacity. They cannot transfer land to themselves. So if the intention was to add them to the title to try and avoid probate, once you've lost capacity, even if they are your power of attorney, they cannot put their own name on titles. You can kind of understand why that might be the law in regards to that. They can't consent to MAID. There's no ability to pre-consent to medically assisted dying, and they cannot consent to end-of-life care. So a couple of final thoughts. Build your estate plan as if you pass away tomorrow. It can be changed in the future, but who knows what's going to happen. Ensure that you're not handcuffing yourself to one plan such that you can't access your wealth, that you can't access your funds that may be needed for your own future care needs. People are living very longer lives. Consider your family dynamics. If your kids don't get along now, they're not going to get along in the future after you're gone, and it will probably get worse, actually. Percentages are easier to work with, and fair doesn't always mean equal. There's my contact information, and if you scan the QR code, I think it takes you to my social media as well if you'd like, and my website. So thanks.